knowledge digital library. Now, all of these concepts are going to link with what we discussed in the last 2 days. So we're going to link it with the Indian knowledge system. And we're also going to understand this in terms of the IPR discussion that we had yesterday, because both of these are combined together. And so the session is rightly placed because I'll give you a glimpse of all of these ideas pertaining to the topic. Now, I hope the second slide is visible. Yeah.
Yes, madam.
Yeah, perfect.
Yes, ma'am.
So these are the 7 titles that I would be discussing, the 7 themes that I would be covering. I know we have discussed about the meaning of traditional knowledge, but just to give a glimpse here again so that I'm able to link it with traditional knowledge digital library, I'll again brief you in a minute or so. I'll also discuss about the problems that led to the discussion of TKDL. I'll also talk about these 2 approaches, the protective as well as defensive approach. And then I will just briefly talk about some sort of folklore protection, because that's also a part of our traditional knowledge and the discussion that we had previously pertaining to the scriptures that we have or the chants that we have. We were seeking answers as to where should we protect them. So in certain ways, we can find certain laws which help us in this process. Of course, this is just to tell you that I would be giving you a glimpse of these laws. As researchers, as faculty members, and as people who are interested in this concept, we can obviously bring about policy changes. We can demand certain ideas and we can come up with papers through which we are able to contribute to this field, and also demand certain rights for the communities which are endangered in this process. And in the last slide, I'll just give you a glimpse of what are the emerging trends in this regard. Now, last 2 days when we were discussing about this idea of traditional knowledge, we were discussing mostly in terms of what's there in our scriptures. And that in some way led to the discussion I was also witnessing in the WhatsApp group, where we were talking about the language discourses that happen. But I think there can be some aspects to it, not merely limited to one language. There are certain ways in which you see that knowledge is developed by these indigenous, local, and native communities, and it could be preserved and passed on to generations. And you may not necessarily see it in their language alone. You will witness it in their culture, behavior, identity. And we start associating a lot of tribes, a lot of communities with certain kind of activities. I'm just generalizing it right now, but you can understand that we might say that this is done by this tribe. This was the culture of this community. So these languages that we are using for them in itself tell us that there are certain knowledge base that have been developed by those indigenous, local, or native communities. And they have been over time developing. So this knowledge alone is telling us that it's not merely traditional as in comparison to modern. We're talking about certain practices here. So it should not become something that we are comparing something that was happening before is irrelevant today. So we are not calling it as an opposition to modern. We are saying there's a traditional knowledge. And the fact that we are talking about it today tells us that it has a value attached to it. And the value makes it vulnerable. And that's where this discussion comes into light. Now, again, all of these communities start seeing this as a part of their culture or their spiritual identity. So people may assume that this is something which I do. So that's how you start associating with those practices, customs, languages, etc. And the fact that they are connected with this community, that's what makes it traditional. That is, it is linked with their traditions, what they are doing, practices, etc. And there is this idea today that it is a very contemporary aspect. It's not something which is very old and archaic and we have to look at it only from a historical perspective, because traditions are being created, traditional knowledge is being created every day. If you think about it, what we are doing today probably could lead to some form of traditional knowledge in the future. So it's a very contemporary aspect. And the fact that it is a contemporary aspect, we should be able to provide certain formal protections to it so that in future also we're able to give certain protections. Like I said, I will be discussing very briefly about folklores, etc. So that is one part of traditional knowledge where you discuss about traditional cultural expressions. where you say there are certain stories, narratives, which are passed on from generation to generations and are linked with certain cultural communities, etc. The impact of it is we see in terms of movies and all, where you see that certain story from certain place or song from somewhere has been taken, and then we say, oh, this particular musician has violated certain rights of a community. So that's where intellectual property law will come into play. So now, with this idea of what traditional knowledge is, the question comes, there are certain challenges, and that's why we need legal protection. If it was very easy for all of us to accept it, we might not go into law and we might simply provide certain generalizations pertaining to it. Now, if you see, the first challenge is that the knowledge is facing the survival or this fact that it might go extinct because the survival of the communities is under pressure. And this community pressure being this kind of survival is also there. The issue of survival is also there because there is a kind of pressure from other countries, or there is migration. When you build a dam, for example, you see the community moving from there, certain aspects of their traditions get dismantled. There is the kind of modern lifestyle that is there. It might just disrupt the traditional ways of living. New generations may not really know about these traditions, and then therefore they may reject them. We were discussing about this aspect of language, which I link with TKDL, that you lose the very language that was the primary idea pertaining to certain tradition. And then you have this concept of diffusion. The tradition becomes very mild in their nature because you're trying to adjust with the changing cultural norms. So that's the first challenge that we are facing, that communities themselves are becoming very different. Second is, when we come to know about certain aspects of traditional knowledge, if we don't know about their scientific qualities, we may start looking at it from a very narrow cultural perspective. When we don't know about, let's say, I've given the example here of a healer, a traditional healer, and these are certain examples also given in the WIPO documents on traditional knowledge. So if you see there's a healer, they may be mixing herbs. They may not explain it to you how they have been able to isolate it. They may not tell you about the chemical compounds. They may also not be able to tell you about the effect of on the body in terms of modern biochemistry. You might not get those explanations. But over generations, they have been practicing it. And the clinical trials that have happened over generations. People have understood the use of these things and have been practicing, passed on that knowledge. So there is some form of empirical understanding, not how we expect it today, but it is there. So this is where we start assuming that these things are not scientific in nature because a kind of study has not been done. But we fail to understand it's not the horizontal study, but it could also be a historical kind of an experiment done through these medicines. Again, today customers now, while we may not respect it, but the Western countries and even a lot of people in India also call this kind of medicine as alternative. While it might be something which is very regular for people using certain kind of medicines, etc. We've been using or certain herbs, etc. in our home is very normal, but it is considered alternative or complementary system. That is not something mainstream. So that's the kind of glamorization of something which is okay. We can use these things because it's alternative now. That's the second challenge that we're seeing, and that's where the approaches will come into play. And now the problem where I'll link the approaches is the fact that you start commercially exploiting these things because the local communities, traditional communities don't have awareness about it. They may lack awareness about how to bring legal claims. There's lack of documentation because a lot of this knowledge, like I said, healer, it would have been transferred verbally to him. He might have practiced at home. He might not have documented it. They may not have economic resources to actually go and file claims. They may not have a group voice. Communities may not really be able to bring out that voice together. They have a very different lifestyle in this case. Lack of policy, and also when the misuse starts. I think yesterday there was also this question about what happens when there is a foreigner coming and going to the forest and misusing the resources available there. You have the Biodiversity Act and the registers that are available wherein you can actually go and raise this concern also. But then there is this commercial exploitation of knowledge. And finally, there's one more point that usually when we start discussing legal claims and matters, usually we try to give individual rights in intellectual property law, but traditional knowledge is usually held by communities. So it's usually a group is taking these rights. So you form associations, corporations, etc. They might be able to help them. One more problem here is that usually when rights are given in intellectual property law, they are for a limited duration. So you might say a patent is given for 20 years, or it might have certain 50 years or certain rights like this. Now, this knowledge is actually through generations. So this makes it a question that how do you protect it? And therefore, world over, there is discussion on how do you protect traditional knowledge, and because it's spanning over generations, and can you really protect it under our modern laws like intellectual property law? Because traditional knowledge has been protected for generations, even when intellectual property law was not in place. So this gives us an idea there is certain forms of protection within the community itself. Now, this takes us to the next part of the presentation. So we discussed about what this knowledge is, certain challenges, and then we need to really understand the fact that all of these challenges are taking us to this idea that you really have to protect the cultural heritage because it's a unique wisdom, and it's unique not in the sense that it was there and it's going extinct alone, but it is also useful today. We know how in COVID we were using traditional medicines. And during that time, we were trying to use all our Ayurvedic medicines, etc., and try to understand how these things function. Secondly, it promotes innovation and entrepreneurship. When we are leading, when all of these tribal communities, native communities today are being displaced, or they are going away from their regions because of constructions, because of globalizations, etc. There is also this concern that you want to empower these communities so that you're able to benefit them also from the knowledge that they have generated. And again, this concept of biopiracy, which I'll link with TKDL, where you're saying that kind of unauthorized appropriation and commercial exploitation that is there without giving them, the indigenous and local communities, the the fact that they have created it or they are the holders of that knowledge. So we have to safeguard this wisdom in this paradigm. Now, that was a third point. Now, in this regard, the theme of this talk was about the approaches that exist on the protection of traditional knowledge. And largely, there are two approaches which are given in terms of the theoretical studies, and also both of these approaches really actually overlap at some point. And usually it's suggested a combination of the two approaches are helpful. So the first approach is that you give the traditional knowledge holders, that is the positive approach, give them the right to take action or seek remedies against the forms of any exploitation that may have. That means in a way, they are able to do some self-help. It's like originating community itself takes some help. Okay, so that's the positive side where you try to give certain exclusive rights to them. The second one is the defensive approach. So defensive, the word itself tells you that you're defending and safeguarding yourself against violations that may happen for your traditional knowledge. So these are the two approaches that are usually discussed in the IP law pertaining to traditional knowledge. And the idea is that the communities should be aware of these two approaches. Unfortunately, because the communities, like I told you, are not very strong in understanding this, and the awareness is not there, both in terms of the fact that of illiteracy, of course, lack of education in terms of modern illiteracy, the language that we have, and secondly, in terms of the fact of digital illiteracy. So the amount of information that we have in the digital forum today may not be accessible to them. So these are the two things which are available. And now I'll move ahead and discuss each of this approach and link it with TKDL. So The first approach, like I said, the positive approach is what we were discussing yesterday also in terms of the intellectual property laws. Now, intellectual property laws and other forms of legal systems that exist, they are actually kind of giving you a sort of the different types of rights over certain things. So it could be a copyright, it could be a patent, it could be a geographical indication, and then there are other forms as well which exist within this regime. Now, the argument, and which India is also looking forward today, is that you create a sui generis system. Sui generis system means you make a law that is specific for traditional knowledge. So right now we are looking for laws within intellectual property law, which is usually dealing with commercialization and all, but we might want to look at a law that purely deals with this vast knowledge, and that should be a traditional knowledge policy or law. And then there are other IP, other models, which I think yesterday also were pointed out, like contract law, trade practices, you label certain things. There are also customary laws. We all know that we have customs and traditions. And even if not for this, you know that in personal laws, in family laws, we have practices. For example, in marriages also, we follow certain traditions which continue. So in a way, we are protecting some form of our traditional knowledge there as well. Then there are other forms of laws. We don't have that much time to discuss about tort law, unjust enrichment, but these are certain claims that could be taken by these communities. So this is just to point out that a lot of us may not be aware of these methods of helping out the communities, or even protecting or going ahead and helping out in forming those research groups, etc., to really bring all of these things together, and then creating a sort of an approach to provide guidance in Indian knowledge systems or traditional knowledge. So this is one set of positive approach. The second set is the defensive approach, where you start taking steps that prevent the third parties from obtaining or exercising certain rights over your things. So that means you start creating a sort of documentation, you start creating a library where you're able to really see that, okay, what is the information that already exists, where you ensure that anybody who's making use of this knowledge today is able to actually compare it with what is already existing. So yesterday, the discussion on turmeric case, etc., you are able to compare that we already have certain things. So, but the problem is, like I said, a lot of people even abroad may not be aware of this fact that yes, India is already using turmeric, let's say. So how would they be aware of it? Now they are, but during that time, maybe they were thinking it's original in nature, and therefore we had to file a claim. So, and this word in intellectual property law is known as prior art. Okay, so this is known as something which is already in existence. Again, in a very general way, I'm telling that it's a body of knowledge that is already available, and it's known as prior art. Now, and you compare the new thing that you're developing for a patent, etc., with this prior art, and say that is it new? Is it something which is of a new value? Is it an inventive step? There is something new that you have offered. Now, this is what the defensive protection is. Now, if you see positive and defensive approaches, both have this component of intellectual property law and other legal methods. Okay, and that's where you see when positive approach comes into play, you start discussing all the existing laws on intellectual property. For example, Patents Act. Okay, now interestingly, Patent Act has clearly given that the traditional knowledge per se is not patentable. That means I cannot say that turmeric is patentable. Okay, I'll have to develop something with that product and show that it is an add-on. Second, we have Copyright Act, where I'll towards the end discuss about musical artistic work. And then you have the Biological Diversity Act. Of course, these are the limited laws I'm discussing. There are policies, there are individual guidelines, rules, etc. for each state also, which you should be referring to, because each state has their own kind of, particularly in India, we have so much of traditional knowledge in each state, and therefore different states have been working towards developing their own policies. And Biodiversity Act is something which again links with the TKDL. Now, in this slide, I would also like to point out how you go ahead with this. I think this was another question that we discussed yesterday. And how do you start processing this information? The first thing is the guidelines have been given by the government itself that you start screening. Okay, you start screening the patent. So let's say I want to file a patent on something. I will fill in the application form and I say I've created this new, let's say, biological product. I've created this extract, etc. And this is my final biological material. Now, this patent application is now going to be seen, and the patent office is going to screen it and say that, fine, this seems like it is of traditional knowledge. Okay. And then an examination will be done and comparison would be made with the traditional knowledge digital library. So this implies that the concept of TKDL that we are going to discuss, it's going to actually tell you that, yes, this is a library with which we are going to compare what this patent office is doing, is the application is filed. So first screening is done, you start examining it. Now this examination is also to be compared with the aspect of novelty or inventive step. I know these things are a little, there are more points to it. There are certain guidelines which have been given by the government, but I'll take one or two examples only here. For example, if the subject matter, for example, something that I want to get a patent on, or if I want to get some rights over it, it is inherently present in the plants. Okay, something which is like an extract or an alkaloid, and you're able to isolate, which is inherently there in the plant itself. You cannot say it's novel. You know, you've not invented it. It's like a discovery. It's already existing. So you cannot really point out that it is something which is a very novel thing. So you may not get a patent on it. Secondly, if there are multiple ingredients, of course, there is a clarification and there are several judgments as well as a lot of discussion in the courts on each of these points. But if there are multiple ingredients of something and they are known to have the same therapeutic activity, taking out one single component out of them cannot be considered as inventive. Okay. So sometimes what happens is that you have several components of a product, multiple ingredients are added. So there is this example I'll give later also, that you combine a lot of products and each of this product has a therapeutic value. And then overall, it's like known as an additive effect. So individual ingredients are already known for the treatment of a disease. And then you combine them and say that it is creating a therapeutic effect. Again, the guideline says that you have to really say whether you can give a patent on this or not. What is the inventive step? So these are discussions, and again, you'll have to add on to it as to how it adds value. Again, geographical origin also, it was discussed yesterday. Please see the link here I've given. I'll share these slides with you because this link is more detailed in terms of these guidelines. I'm not explaining all of these in depth right now, but you have these guidelines in depth given in this guideline here. So you'll be able to understand what I'm speaking in terms of the combinations that are being discussed. But again, when you see the geographical origin of the biological material, that also you have to indicate in this application. And if you're using something from abroad, or if it is a material that is used elsewhere, you really have to take it from the National Biological Authority. You have to take permission from it for it, because it's something which is showing the source or origin of that product. And like I said, geographical origin itself can give you certain ideas that this product may belong to a certain community in itself. The example, like I said, is about this patent application. So it was an application which talked about the combination of tea and a herb Shankpushpi Satavari, which we know, and a mixture for the treatment of a disease related to immunity, so cold influenza. So the application, for example, this is given again in the guidelines. So if you see this application, you try to compare, like I said, second step, this application is received. Second step, what happens is you start looking into the existing material that is there, the prior art. So you start looking at it and you say that we have realized that in our library, each of these plants independent use of the set plants are also helping in cold. So when I use tea, it might help in cold. And when I'm using all of these things in Unani as well as the Ayurveda medicines, all of these may have certain treatments of cold. So how will the application be analyzed apart from the other aspects to it, which would be more scientific in nature? The claims relate to the composition. So what the person is claiming, I'm filing this as a composition of tea as well as Shankpushpi, Satwari, etc., and a mixture for the disease. So here you look at the prior art, you realize that these have been used for generations as popular medicine in household, and the potential of the Satwari or even Shankpushpi has been disclosed in our documents already. So in a way, this becomes a kind of traditional knowledge. Therefore, you're not creating any inventive step here. Now, I know we will have questions as to then how are we getting certain medicines produced with all of these components added and the medicinal products. So a combination would obviously lead to treatment, but then you have to, for commercialization, you have to create certain ways in which the traditional community also benefits, or the government is able to commercialize it in a way wherein you keep on protecting the traditional aspects of it. So this is how the guidelines have given certain information. So like I said, I'm discussing the positive approach right now, gave you certain understanding of these three laws. The first one, patent right now, copyright I'll discuss in terms of folklore. And we'll also discuss about the Biodiversity Act when it comes to the understanding of TKDL. Now, I wanted to also give out this IPR policy of Kerala of 2008, because this is very interesting and it has created a new term known as knowledge commons. Okay, and this is one of the policies which is, like I said, each state might have its own policy. So this is one policy in Kerala, and what it has done is it has decided that traditional knowledge will be something which is going to be in the domain of, and not in the public domain, but it will be a kind of knowledge commons. They've used this term knowledge commons. And therefore, the community or family custodians, like I said, some information passing on from generations, will have the rights to the knowledge which belong to them, while the rest of the traditional knowledge, that means if I'm able to identify the community, it will go to them, it will belong to the state. So even if you want to commercialize this knowledge, you will have to take permission from the state. So like it's written here, no entity which is registered may be deemed to have any rights on these things. Any community family custodian of this traditional knowledge will have to register as a knowledge practitioner with the Kerala Traditional Knowledge Authority. So like we were discussing yesterday, where should we go for these things? Each state may have a policy of its own. Again, all the rights holders of this knowledge will have certain forms of license here. Okay, under this license, the right holders permit the other. So let's say I hold certain traditional knowledge, I will be permitting somebody else through my license that you can use it for either commercial, non-commercial purposes. And if I'm using any development over it, I'll have to put it back in the knowledge commons, because now it is going to be used by the state. I cannot patent it. So the policy is also proposing that, like we were discussing yesterday, for all foreigners who are making any application, they have to make it through the National Biodiversity Authority, so that they could refer it to the state authority. Now, this tells us that we have understood the value of what is happening in terms of traditional knowledge. We've also taken into account that there are foreigners who are making use of this knowledge, and we've understood it through the series of patent cases that have been filed world over. Now, this policy is one of the aspects that we are catering to, but then each state you can refer and search, and you might be able to find, and you can even do a comparative analysis of these policies to understand which is the best one, and maybe come up with certain suggestions. Now, the fact that patent laws, copyright laws, etc., exist within the IPR regime, there are also certain other ways, and other countries have used it. For example, unfair competition. Here, the example is of some sort of aboriginal painting. But let's say I start selling some painting and say that it is an original Madhubani art made by some handicraft person, so and so at so and so place. then the person can really argue, okay, that this is not what has been done by our community. So that's an unfair competition because you start selling those goods, and that becomes a part of not merely IPR, but it also become a part of trade law. Okay, so when you start studying these positive approaches, you should also know that it's not merely intellectual property law. You can always have certain other forms of law, like trade practices, etc. Then you have certain signs, trademarks, geographical indications, like I said. For example, this in Mexico, this happened. There was the Seri people. They faced a lot of competition from one of the groups, and because they were trying to use a certain form of traditional method using authentic ironwood, and therefore they decided to really register it, and they were able to then register it as a trademark and produce it on their own. Because when you start competing, so local communities may not produce in mass scale. They have their art and they try to produce it in a handicraft way. And if you start industrializing it, there might be mass production of it and the quality would be different. So this Mexican tribe had to really fight it out and really decide how do you register their own kind of art. The third part is about confidentiality and trade secrets. This is another form of intellectual property where we see, like I was discussing, a lot of things are passed on, like doctors, etc. The information is given to the people orally. Sometimes it's written also, but most of the times you may be doing it through practice. So this makes us understand that you might have to, and each community may have certain laws that, this is the confidentiality. This trade should not go out of our community. There are certain things which you want to protect as a secret, even secret recipes, for example. You might want to just save it in that regard. So people may have certain confidentialities and trade secrets. There are ways to explore this method also to protect the right. Now, other final legal aspects, and then moving to TKDL, is you take permission from these groups. That's the simplest thing one should be doing. When you're using, you are aware of certain knowledge about that this is being used in this region, you can really consult them, the traditional knowledge holders, and you can take help from them, because that's really helpful if you're able to take help from them and understand and develop it further, because they are the people who have used it for generations. You can create equitable benefit sharing. That means the Kani tribes, I think the example, and I'll repeat it again, about how they have really helped in the development of benefit sharing agreement. And I pointed out the sui generis protection. You really need a law of its own kind for the traditional knowledge, because intellectual property law might just be more towards industrialized products, commercial products, globalized regimes. And therefore, you might need a law that aligns with the traditional aspects of each country. We have this bill which is pending, the Protection of Traditional Knowledge Bill 2022. And if it comes into light, we might have an add-on and very good discussion on how to go ahead in dealing with traditional knowledge from this regard. The example of Kani tribe is mentioned here. As you can see, the communities as such do not really benefit from what they are doing because they've been using it as a part of their daily livelihood. It's not something that they were using for commercial purposes. It's only that you've realized later and you start using it. So this tribe led to the development of a drug known as Jeevani, and which was an anti-stress drug based on the herb Arogya Pacha. And the Indian scientists, they were able to really use this technical know-how, and the Tropical Botanic Garden and Research Institute, they made this drug Jeevani. And how did they make it? They involved the tribal community. The tribal members were actually able to transfer certain knowledge to them because it's oral and it is held by the traditional healers. They were able to isolate the compounds from this, and then they filed patent application on it. Then, through licensing regime, it was passed on to the Ayurveda pharmacy, and a trust fund was established so that you're able to share the benefits which are there from this drug. So that means whatever they were doing in this process, they were entering into a benefit sharing agreement with this tribal group. Now that's how you can really use this knowledge, because now you're not merely able to use this knowledge for the benefit of the mass community, because protection does not mean that you cannot really take it to the wider community. Protection also implies transfer of this information in such a way that everybody is able to take benefit of it and without harming the other person. That's the whole idea of intellectual property law, that whoever creates it should be able to get benefit of it. And therefore here, if they have this, not merely creation, but they have a kind of ownership of this valuable information, there should be some kind of value attached to it. Now, and this is what is linked with their customary aspects, that you have certain ways in which they protect their knowledge in terms of secrecy. They also may have certain ways in which they may decide that this knowledge will not be transferred outside our tribe, right? They may have certain laws pertaining to this. So that is also something which is a kind of respect that is to be given. And so this is one form of customary laws and practices. India is very strong on customs and traditions, and we really abide by a lot of customs and traditions in most of the aspects. And therefore, in terms of traditional knowledge, within each family structure, within each community, we have those, and we continue to follow it. And we may not want to really cancel the kind of, we may not want to really divulge it also outside, or may not diffuse it. Now, the final part of it is the traditional knowledge digital library. And so, as I said, with the understanding of traditional knowledge, challenges, the protective as well as defensive approaches that are there, you really need to now understand, where do we find this information? You know, what is traditional knowledge? Where is it recorded today? So for one aspect of traditional knowledge that is pertaining to medicine, we have the traditional knowledge digital library. GIs I've already discussed, Darjeeling tree, etc. You can get protection for it. And linked with TKDL, there is also this community biodiversity registers, where communities are encouraged. And again, it becomes a part of us as researchers, faculty members, or anybody who's interested, that we create this form of awareness amongst the people, that they go and really give out this information to the communities. Please come and document this knowledge and register it here, so that it could be saved and protected. Now, TKDL is the initiative of our government, and we know that still a lot of us continue to use the traditional medicine, and the fact that it is being used and commercialized leads to its vulnerability. So what TKDL has done is that we've understood, and we were discussing about the language issues. Most of our traditions are in different languages, and most of us may not understand each other's language also if you start discussing about certain complicated terms, etc. So the languages like Sanskrit, Hindi, Arabic, Urdu, Tamil, any of these languages, or the dialects, if you go from region to region, you will have different dialects also. So all of this, and the text in all of this, so what they've done, a lot of this literature was not understood by these people, the patent examiners. So when you have to fight for turmeric or any other compound, ashwagandha, etc., you might not be able to understand that because it's in different language altogether, right? So the international patent offices were continuing to grant patents because of this lack of knowledge, and we understood as that this traditional knowledge has to be protected. So what TKDL did, it overcame this barrier, and format by systematically and scientifically, it started structuring these ancient texts of the Indian knowledge systems on Ayurveda, Siddha, Unani, Yoga, etc. into 5 international languages. So now they've converted it into English, Japanese, French, German, Spanish, with the help of technology. So this is again something important. A lot of us are coming from IITs, etc. There's a big role one can play in creating these databases, because that's very important for people maybe illiterate in terms of digital literacy, but you can still have some sort of a structure where you can document this and spread it across to them. We should be able to create that easy access. So what they've done, converted it into these languages, and they've also created a classification system, traditional knowledge resource classification. So a library bana diye, there's this library which has this information in so many languages, And this language now has the classification also. So that question about if everything is in Sanskrit, then what? That we were discussing. We have, at least for this medicinal, we have translated it into language that is not merely understood by Indians, but also by other countries, because that's how the patent system works. It could be, they would be researching anywhere. So this TKRS, what it has done, it has arranged everything and it has started to disseminate this, and it has created several subgroups. So it says this is the medicine, this is mineral, this is the disease, these are the effects, this is the animal resource, this is how it is prepared. Everything is given in this. So right now it is based on the system of medicine, and it acts as a, so like I was discussing about prior art. So now when a patent office anywhere, the cabinet has actually approved 16 patent offices. European, suppose in Europe, somebody's doing some research, wants to file a patent to see prior art, they will go to this TKDL. India has already entered into an agreement with Europe, Japan, and several other countries. And through this, they will be able to share this information. And this is very, very helpful. This has been a landmark achievement for India, because these are the number of books and texts that we've been able to really transcribe over time and translate on Ayurveda, Unani, Siddha, Soa, Yoga. 281 texts and volumes have actually been. All of this information is available on TKDL website, and I'm using the website itself for collection of this data. The other thing, now that being said, how does it work? It has taken all of this information, transcribed it, and like I was saying, technology is very important, programming is important. It has coded this information into the database through translations, and abstraction is done through subject experts. They're able to then classify it and also translate these classifications. For example, something which may not be known. So for example, like turmeric, people may know it as curcuma, or musorica, smallpox. Okay, so all of this information is now in different languages. So modern terminology is used. So traditional as well as modern. And then it uses a proper interface, Boolean search, etc. So how you were able to really search the interface like any other database in multiple languages. Now, how has it been successful? And I'll just move to that slide. It has been extremely successful in the fact that initially it was very costly when turmeric cases happened. And yesterday it was discussed, Girish sir had discussed that it led to a huge amount of money being spent. But if you see here, we have been able to win so many of these cases through this process. We've been able to reject the patent applications, modify them, as many as 340. So people have been filing patents on our traditional knowledge world over. But with this, when they start comparing it and looking it into our TKDL, our library, we have won and we've been able to reject. So Europe, US, you have in Canada, Australia, and also UK, everywhere. We've been able to find out ways through which we've rejected the examiners, the patent authorities in their countries, went into our TKDL. They saw that, oh, this product is already being used as a traditional knowledge in India. Therefore, you cannot be granted patent. So this has saved money, because now we don't have to file claims again and again in the countries. This has led to a creation. Now, this is only done right now for medicines. And it has saved a lot of time also, because it's just the application has to be verified against these documents. So right now it's largely for through Biodiversity Act and medicine, but we are gradually moving towards this idea that probably for other things also we can create such library, wherein we're able to understand how to process it. And this system has worked very well for India so far. Now, to summarize what TKDL does, it's able to list the sources, oral as well as codify. It has been able to create an access. So even if you want to read, you go to this website, open the Ayurveda text, we're able to see what all books have been referred to, what all information is there. So it has made this information accessible to all of us. It has aligned it with modern terminology, the problem that we were discussing, how do we understand it? Let's say I don't know Tamil. So how do I really read that text? Right? I am an Indian, but I don't know that language. So how would I be able to do it? So let alone any person from other country. So I might have to either learn or use a translator, but this system has created this possibility because each language has to be respected and the understanding also has to be given to all. Then classifications they have made, they've been able to create team of local experts. And then you have the IT team coming in to create these libraries in multiple languages. I'll just take last 2-3 minutes. This we discussed yesterday, so I'll not repeat. But these were the cases in which we were able to really spend a lot of time and money in protecting our rights over neem extracts, as where Europe had given a right to one of the companies about it being something original. But now I think if they want to give a right, they can just refer to the TKDL and they would know that this tulsi, for example, or any other thing is mulethi. All of these things are there, which have been used for different purposes in our country, and therefore they might not. Turmeric again, it was one of the first landmark judgments where traditional knowledge was of a developing country was successfully challenged. And apart from all of these discussions, so apart from the two ways in which you can protect, we also have this idea of TKDL now. The last part is the folklores, that is the vibrant culture that India has, and each state has so many different dance forms. We have so many different songs, stories, dramas, plays, etc., music. All of this also seeks some form of protection, and these are also a form of traditional knowledge, which will get extinct, like I said, because the communities are changing. We may not know what dance forms existed in our traditions earlier because they might have modified over time. So this is given protection under different laws. For example, Copyright Act 1957, it says that you can have literary, dramatic, musical, artistic work, plays, etc. They can be protected. There is a specific law, Folklore Protection and Registration Act, which grants you rights to protect all of these things. And the GI Act, which I've discussed, the Tirupati Laddu, for example, you protect these things, the unique products and crafts, and you identify them and give a GI tag to it. Of course, it's a process. You have to fill the application and give these tagging to the products there, and which has, again, links with the traditional knowledge. The repeated examples are usually of the Chow dance. The government was able to challenge it in terms when it was used by a foreign production, because they said these are the rights of a particular community. And if you're using their dance to suggest that this is something new, or you're commercializing their steps, you should be able to understand this is a traditional culture of their community. Paintings, again, in Maharashtra, they were able to revive these paintings through the artists, etc., and were able to give. So like I said, Madhubani, etc., I cannot claim, I may paint something and say it's original Madhubani art. Not like that. You have certain communities that are working, who are experts in it, traditionally learned, they have their own ways to develop it. And therefore, this was another example. So with this, I think I will look into the comments and questions, and I'll hope that I was able to really give out some pointers as to how the law is helpful in traditional knowledge. And today, as we move ahead, we should know that there are ways in which we can help the community. In the emerging trends, one is by bioprospecting. Bioprospecting is where you start using the community, involving them, and start looking for IPR. Like I gave example of Kani tribe. You engage with them, involve them in the process, and not segregate them for your selfish motive. You start using technology. You start documenting it. You create platforms for it, because it's not blockchain merely. You have so many forms of AI today. It can really either destroy the art because it can replicate it so fast, and therefore we might need methods to save the culture again. And like I said, during COVID time, we definitely understood that indigenous knowledge systems are very important in global health challenges. And if we're able to use them properly, we might be able to really take advantage of this fact that we have a system that would be much more helpful than the modern medicine, or may actually add on to what is there in the modern medicine. So with this, I'll just stop. But I really hope that in some way I've been able to contribute to this discussion. And these were just glimpses, but I really hope, I look forward to the questions and discussions now. Let me just stop sharing this slide.
I want to extend my heartfelt gratitude for this captivating session you led on traditional knowledge. Your ability to convey this with depth and significance of this topic has left us with an impression on all of us in attendance, ma'am. Thank you so much.
Thank you, ma'am. Thank you. I'm just trying to close this just a second. Yes, ma'am. So I'm so thankful because I think this discussion, there are so many components of it that could be discussed, and it requires a lot of time because each of these laws are very in-depth. But I really hope there was some addition to the knowledge base that people have here. Thank you so much, ma'am.
Thank you, Jayashree teacher, suggesting Garimaji's name as resource person.
Yes, Rekha Shri ma'am has been very kind because I think this was, I was also a little skeptical because it was more about Indian knowledge system. So I thought that I will be able to integrate the aspect of traditional knowledge or not, but I'm really happy that the discussion fared well here. Thank you.
Because it was a complicated and subtle subject.
Yes,
I have
sir.
suggested the topic and name, but fear to find out a right resource person.
Thank you, sir.
You have nicely presented
Thank
and explored the subject well.
Thank you so much.
Thanks for the wonderful session.
Thank you. I think we have some questions here. Yes, Sridhar sir.
For a great session. I have a question.
Yes, sir.
I have about the extraction process. See, you talked about some of the plant-based ingredients cannot be patented. Agreed.
Right.
But suppose if I come with a process to synthesize that or extract that, can that process be patented?
Yes, India does allow for process patents.
Yeah.
Yes.
Thank
Yes,
you.
and because you're creating some new method here,
Exactly.
of course, and so it could be patented. Yes, sir.
Okay. Thank you.
Thank you, sir. Yes, Manisha, ma'am.
Yeah, ma'am, it was really a wonderful session and it was a good insight on patenting. I just wanted to know, so whatever knowledge you have shared, like it is a great initiative that a library is created for protecting the traditional things. But is it an initiative by Kerala government or it is like done in the central government? Because
It's the central government that has done. Kerala, of course, has its own policy, but this was the ICCR and the other ministry, they have developed this complete library. So it's not merely Kerala's initiative.
okay,
Because if you want to read the text from complete India, you might have to have a initiative throughout India for this.
okay, because I can't see any such kind of initiative in Maharashtra because there are many, like Kerala, Maharashtra is also rich in traditional knowledge.
Yes.
This is a good initiative and this can be started over here also. I don't have any
So,
idea
ma'am,
about
actually, TKDL is something which could be accessed by anybody from any part. So, if there is something in Maharashtra that requires certain form of protection like this, TKDL could be approached and discussion could happen in this regard with them. That there is certain form of traditional knowledge which could be now translated from Marathi, let's say, to these languages, and it could be protected. So, TKDL is a pan-India initiative. So, it could be used for that purpose, ma'am.
but there is a very less awareness among the people regarding the patenting or protecting their traditional knowledge.
Yes, and I think this initiative is of one of a kind, like we're sitting here and probably it would just give us this idea that some of us can form certain forms of research group, approach certain NGOs who are working in this field, approach the lawyers who are working in this area and take help from them to understand how we can make this whole process easy. because it's a part of us. I mean, laws seem complicated, but they're actually not in that sense, because they're mostly to help us out in this regard, and particularly these laws.
Okay. Yeah. Thank you so much, ma'am.
Thank you, ma'am.
Really wonderful.
Thank you. Thank you.
ma'am.
Senthil, sir.
Am I audible?
I think the voice is breaking, ma'am.
Is it audible now?
Yes, ma'am.
Ma'am, you just said about that TDIL and how we can protect our cultural values. So, like in Maharashtra, we have some for Paitan region, we have Paitan paintings which are depicting for Ramayana. So,
Yes.
for such kind of things where we actually don't know exactly, but whenever we do study and we want to apply for it for their patents or some copyrights, so how can we proceed with government? Because maybe I'm asking is this because one of my friend and we are collaboratively working on that research, and since if we are researching, so government is actually not playing anything in that. But then whenever we will be having some patent, so can we form a patent with government as well? And the second question is, I'm from engineering college and from computer engineering department. And
Yes,
my many of the students and college projects are having there, which can who are working on various development of websites and mobile apps for making this all information available to general people. So that patent, suppose I'm working on any research culture, so that patent would be applicable to my institute or to our government or to only me or my friend, whoever are working.
So patent ownership will depend upon what you're filing. So in
Okay.
your file, you would be writing who are the patent owners. Now, when you're applying, in case the government finds out that this is something purely of a traditional knowledge nature, they might decide on putting it in this TKDL and not giving you patent. But in case you are able to give the ownership, whoever is applying, they get the patent in this regard.
Okay.
Okay, so it would be you. And the first question, ma'am, was pertaining to the I'm sorry, first you had one more
We are
question.
actually working on this. As you have said that the patent ownership would be with any of these people. And second is if we are working on any website which is which is related to this kind of research, but since I am from institute, so my students would be working on that. So
Right.
that my affiliation would be from my college.
Yes,
The
yes, yes.
institute I'm working. So in that also that patent would matter, or the website would be a separate entity.
No, I think it would matter in that sense also, because if you are having it in the university, usually university also gets certain rights. I mean, depending on the patent application, because they are providing you the instruments, they're providing you the resources. So they have certain, they can in a way try to commercialize that patent, because based on the patent, they try to make certain products, etc. So that is very much possible. But yes, it would be, again, your right. You'll be owner, and then you will be able to share it with the others based on the agreement that you enter into. So this is purely, again, agreement based. Unless it is something of some indigenous community that you've used, then you might have to enter into a the benefit sharing agreement with them.
Okay. And the one which you have said that if we are going to represent our culture in another countries through various government programs. So in that case, how should we approach to government for this program if we are willing to?
So I think TKDL is the best way. If you have certain aspects, you can approach them. And again, we are with a group that would be able to help us out. Right now, you're attending the FDP itself. You should contact the organizers, and they should be able to guide you in the process, because they're working towards the protection of traditional knowledge. So the government entities are approachable in this regard. If you have certain projects, if you have certain ideas, you can absolutely apply for those fundings as well. And with the NEP, I'm sure that we will have certain projects coming up with which will help us in circulation of this knowledge, which is mandatory in certain ways if we are losing out this knowledge today. Yeah.
But then, means my experience was we were trying for funding from IKS division of Government of India. But then from many months I'm trying, but it is not opening any of the new upcoming grants. So that's why
Yes.
down that now, how should I approach? How can I proceed with some research works and patenting, etc.?
I think that also depends on the government when they open up the grants and all, because it's all a policy initiative. But I'm sure that different groups, you'll have to search for projects, not merely in India, but other countries also. They would be able to really sponsor a lot of things for our projects. So apply to the government, and once you have these possibilities, once you start having that discussion more and more with the government, if you provide the utility of your project also, no, they might be able to support the grant in that regard. Yes, ma'am.
Thank you so much, ma'am.
Thank you, ma'am. Okay. So, any other question? Kanishka Gupta, ma'am.
Good evening, ma'am.
Good evening.
Ma'am, as you have talked about so many things like intellectual property law and this patent law, but on the ground level, if I'm just seeing around us, there is a lack of awareness. So in that condition, what would be our role? And as you know, the people who are involving in the cultivation or in any other area, they don't know about this type of law. So how
Right.
they can use and these laws are being effective in the ground level?
Right. So, see, I think it becomes the responsibility of the educated community in this regard, because government can only do so much. We are aware of these laws. We might be aware of certain policies, and as citizens, I think it should be our role also as faculty, as researchers, to maybe plan out certain short projects in our college, not just projects, maybe you just run an awareness session somewhere in the community. Of course, take help from the government, because they have these biodiversity departments. Like I pointed out, state departments are there, IPR sections are there. You can approach them for these grants. IPR section works very well in terms of creating awareness sessions. We have training programs and workshops through them. You can discuss with them, decide about the community where this information has to be spread, and it could be done. The best way would be to involve maybe some senior people from that community itself in this process. Once you involve them, they might. So if you involve certain seniors, make a group with them and try to explain them, because language barrier might be there. So you should be able to then decide with the IPR group, etc., to be able to guide them. So involving the community in itself, because see, we are saying they have they have illiteracy and those things, but they have huge knowledge. They have knowledge, the literacy in terms of their own knowledge, their own culture, their own language. So their literacy is only in terms of our modern language right now. So that's where their illiteracy is, and therefore translations could help in that regard. And a couple of people from those communities have moved out and would be able to help out in these translations also. So I think it becomes the responsibility of educational institutes, as well as the responsibility of the NGOs who are working in this field, and of course the government will help out in the process.
Ma'am, as I'm working in the education department, but during the competitive exam, preparing for the competitive examination, I just come to know about the GI tag. As you have discussed right now, that GI tag is what? Like in Bihar, if we are talking about in Bihar, to makhana and some chawal, you can say that special quality of chawal rice has got their GI tag. So if we as a educated person are not able about don't know about this patent law and this intellectual property law and GI tag, so how can we expect that these illiterate people who are involving in that area just come to know about that this type of law? So that is
Absolutely.
very challenging to implement all those things on the ground level. I just think this.
Absolutely, ma'am. I agree with you. It's very challenging. We might not know around our places what many cultures, types of medicinal properties, etc., are available around us. I think it's challenging because we don't have that kind of a group effort right now. Over time, and I think the initiatives have started over time, probably we'll be able to pass on this information. Laws usually cannot function unless people are aware of it, like you rightly said.
And one more thing, ma'am, I would
Yes.
just want to share with you that most of the in the urban area or rural area, if we are especially talking about the rural area, the people are just get rid of the cultural, their own culture because of the
Yes.
modernization. So in
Yes.
that condition, it is very challenging to bring back to their own culture, their own knowledge system, Indian knowledge system, basically, and indigenous knowledge system. So in that condition, what you just suggest?
That is true. I mean, just imagine this thing that a lot of our cultures, even in our families, have changed over time. You know, it's the way we deal with a lot of things have changed over time. So the cultural diffusion is going to happen, acculturalization is going to happen. And that's where the idea of protecting whatever we can comes into play. Government, like I said, is trying to translate it into different languages, and over time they might be able to further do it. But again, like it's a challenging process altogether, and it's the citizens and it is all the community that is aware or maybe want to get information. So let's say somebody today gets interested in knowing more about intellectual property law, they can do a short course on it, a certificate course on it, understand the deeper aspects of it, get associated with the groups, help out those local regions and understand. But again, see, you'll also have to understand what is traditional knowledge in that regard. Not everything might be traditional knowledge. So that also has to be reviewed and studied. So that is also a long process. Of course, like you said, it's challenging, definitely.
Thank you so much, ma'am.
Question,
Thank
ma'am.
you.
Dr. Jitesh Krishnan has raised his hand.
Yes.
Do you please?
Yes, yes, please.
Yes, sir. Raised his hand twice, ma'am, and that's why
Okay, I couldn't see. Yes, ma'am.
No issues.
Maybe is he there in the meeting?
Need to check, ma'am. Okay. Any more questions, participants? If not, we can go straight away to the vote of thanks. May I please welcome Gayatri to please propose the vote of thanks.
Ma'am, am I audible?
Yes, ma'am.
Good evening to all. Respected our resource person, Professor Dr. Garima Tiwari, organizers of this FDP, and dear fellow participants. With immense pleasure and privilege, I wish to extend our heartfelt gratitude to all those who have made this session possible and meaningful. Today's academic session was a wonderful session that has undoubtedly expanded our perspectives and deepened our understanding of the significance of traditional knowledge in our rapidly evolving world. On behalf of the organizers of Faculty Development Program, NSS College Pandalam, IQC and HRDC cell of the college, and all the participants who attend the program, I extend my heartfelt thanks to Dr. Garima Tiwari ma'am for her insightful presentation and discussion. Thank you, ma'am. I would also like to express my gratitude to the organizers of this FDP, especially Bharat Vidya Prayojana, a division of IGNCA, and Chinmaya Vishwavidyapeth, whose planning and efforts have ensured the smooth execution of this session. Furthermore, I extend my sincere thanks to Principal of our NSS College, IQC team, and conveners and members of the HRDC cell and technical supporters of this FDP. We are also grateful to all the attendees who actively participated in this session. Truly, your presence has made this session a dynamic and a stimulating one. Once again, thank you to everyone who contributed to the success of the program. Thank you all. Thank you.
Thank you so much. Thank you, everyone.